Hi, Wes Scott from Lifeback Law Firm. Today we're going to talk about selling property prior to bankruptcy in Minneapolis, Minnesota. It's a good blog by Dr. Amanda Rosback. As a general rule, you don't want to be transferring assets prior to filing bankruptcy, and you definitely don't want to do it without the consultation of a good of a good lawyer, and to be honest with you, a lawyer at Lifeback Law Firm. That's who you should go to. But generally speaking, what we're looking for when somebody says, yes, I transferred assets prior to bankruptcy, well, what we're looking for is, was it transferred for fair market value? In other words, did you get what you could get for the item on the open market, without preference or bias to anybody? I mean, you got what you could try to get for it. And if so, it's generally not a problem. But if you've transferred the asset for less than fair market value, I mean, you gave your cousin Vinny a $5,000 break on your truck, that's a problem. It's considered a fraudulent transfer, and trustees in bankruptcy, especially a Chapter 7 bankruptcy, are able to go back and sort of claw back the value that Vinny got that he shouldn't have got. Now, again, these rules are rules in bankruptcy. It's not that you did something necessarily wrong. You probably like your cousin Vinny. I'm sure you do. And giving him a break in most situations is probably not a problem. But you see, when you file a bankruptcy, there are certain rules that we've all agreed upon. And one of them is, hey, if you've given somebody value for nothing in a certain time frame, a trustee can claw that back and disperse it to everybody pro rata. That's the rules of the game. That's the way it works. It may not seem fair, but that's the way it works. That's what we've all agreed upon. When the time is right, when you are ready to get your life back, reach out to Lifeback Law Firm. You're going to be so thankful you did.